Putnam can catch up on that. So why don't we open up the agenda and do the roll call.
Okay, we will get it going.
All right, it is 9:02. Good morning, everyone. We're allowing folks to Zoom into our meeting. This is the Colorado Oil and Gas Conservation Commission. We are undertaking the 800 series in rulemaking, and this morning we are set up for closing statements from our party participants, 3 minutes per group. We will allow folks to continue to Zoom in. It looks like we've leveled off at about 48 participants. Hearings Manager Larson, would you like to take the roll call, please?
Yes, Mr. Chair. Commissioner Bogue.
Here.
Commissioner Gonzalez.
Here.
Commissioner McGowan.
Here.
Commissioner Misner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Putnam. Commissioner Robbins.
Here.
Mr. Chair, you have 6 out of 7 commissioners present.
Excellent, great, that's a quorum. We are good to go. Again, we received yesterday the staff recommendation with a red line on the rules and the statement of basis and purpose. That was after deliberation and direction from commissioners. We will this morning hear short closing statements with regard to that recommendation, and then we will turn it over to commissioners for deliberation. So with that, I believe our first panel is 350 Colorado and the Lookout Alliance. If we could get them into the panel, we look forward to hearing from them.
Yes, and Mr. Chair, I'm not seeing Ms. Steiner in the meeting at the moment. If Ms. Steiner is in the meeting, or another representative of 350 Colorado who would like to make the 3-minute presentation, if you could raise your hand and we will promote you to a panelist.
Looking.
Mr. Chair, I'm not seeing anyone. We can certainly keep checking for them and then come back to them once they're in the meeting. And we could move on to the industry group, and that would be Ms. Ryan and Mr. Martin.
That sounds good to me. So we'll put a little check, a little asterisk or something besides the 350 group and come back to them once they're able to join us. And I see that you're bringing in Ms. Bryan and Mr. Martin. We look forward to hearing from them.
Jim, I'll kick it off.
Good morning. Good morning, all. Good morning, Chair Robbins. Good morning, commissioners. Happy Friday. There is light at the end of the tunnel. And I'm here to provide some added impetus to that. My comments are very brief. API Colorado wants to recognize and applaud the extraordinary efforts of staff over the course of the last 36 hours to find a way to address the concerns that have been raised by a number of parties with respect to the 800 series rules. We understand that they're working under a lot of pressure and that everyone's tired and they've worked hard. But this is another success on Director Murphy's part and those of her staff members. So again, a thank you, and we have no other comments except to say that we appreciate their efforts and we support the rules as revised by the staff and as proposed to the commission. Thank you.
What a lovely way to start the morning, Mr. Martin.
You're very welcome.
This is Julia Ryan for the Colorado Oil and Gas Association, and I could nearly conclude my remarks simply by saying ditto. We very much appreciate staff's hard work and all of the efforts over just a brief period of time. So COCA does largely support the new rules, including those released yesterday. That being said, COCA does still stand by the rules it presented earlier this week, particularly regarding 802D for automatic public hearings upon request, and Rule 802B for exemption criteria surrounding depth. Otherwise, COGA particularly appreciates the clarity in 803F1 about 10,000 barrels of water being the applicable standard, and the clarification around the Form 2A issues that we've discussed extensively. So other than that, thank you very much.
Likewise, Ms. Ryan, lovely way to start a Friday morning. Appreciate it. And we echo both of your sentiments for the fine work of staff and the fine work of the quickly gathered stakeholder party group that helped facilitate getting to the draft that we're at now. Flipping to the next page, I believe the next group is the Battlement Concerned Citizens et al. Group, Conservation Colorado, Western Colorado Alliance, Grand Valley Citizens Alliance, and citizen groups. And Ms. Larson, whenever you see 350, we'll get back to those guys.
Yes, indeed.
Good morning, Mr. Sura. Are you leading or holding the charge for this group of fine stakeholders for us?
I am, thank you. I want to echo what was stated earlier. We agree that a lot of great progress has been made and really appreciate the fine work that you have all done and the staff has done to bring us to the place we are. I do have a couple comments, however, and so it's not going to be quite as quick as the industry presentation. We agree with the proposed changes to the statement of basis and purpose. It clearly lays out that conversion of a production well to a waste injection well may require a Form 2A, and that was a possibility that wasn't really contemplated with the earlier draft. But when we're getting into the draft rules, it's not as clear as it might be. And I want to just read to you this section here in 2 that's enlarged. For proposals to convert an existing well to an injection well that would not otherwise require the submission of an oil and gas development plan or Form 2A, the operator will, and then it goes on, and I agree with all of this down here in A and B. However, I believe that within a year, within several years, an operator that didn't have the benefit of this discussion, an operator that hasn't familiarized herself with statement of basis and purpose, wouldn't realize that it might require a Form 2A. And in the cases that we cited, if there's going to be a lot of truck traffic, if there's going to be a reconfiguration, this reads to me as if a Form 2A is not going to be required. You have to read the statement of basis and purpose to know that it might be. And so I would just make this quick change after a Rule 304A analysis. So it would read, for proposals to convert an existing production well into an injection well, that, comma, after a Rule 304A analysis, would not otherwise require the submission. The other quick change that I'd like to propose is to the statement of basis and purpose around these injection wells and induced seismicity. Right here is, it talks about the fact that there is going to possibly be some cumulative impacts to seismic, to some of these injection wells and pressures over time. And it says the rates and cumulative volumes of fluids injected in the proposed UIC well may pose a specific risk to induce seismicity. Well, as was stated both in your discussions and that we presented, it's also multiple wells in the same formation that could increase the risk of induced seismicity. So propose this language here, the addition of this language, or to the same geologic formation by multiple UIC wells in the area may pose a specific risk of induced seismicity. Again, just want to, I think that would be helpful for all stakeholders to understand that if there are multiple wells in the same area, they may pose a greater risk and therefore may trigger a requirement for some seismic monitoring. And that concludes my statements. I'm open for questions if there are any.
Thank you, Mr. Sura. Commissioners, are there questions for Mr. Sura on behalf of the Battlement Concerned Citizens, etc. group? All right, seeing none, we will check back in with the 350 group, and if not, move to be the change, I believe.
Yes, Mr. Chair. I still don't see a representative from 350 Colorado in the meeting. Again, if someone has come in and we just haven't found them, please raise your hand. But we do have Mr. Doe from Be the Change in the meeting, so I can promote him to a panelist.
Let's do that and hope that his audio is working. We had some difficulties there in the past. Good morning, Mr. Doe. We see that you are a panelist. If you could unmute yourself, hopefully we'll be able to hear you.
There we go. Good morning. These are my comments. They'll be brief. They're a repeat of what we've already said. I guess we'll continue to repeat them until somebody listens. We can only repeat and continue to repeat that your job is to judge whether oil and gas activity is protective of the public and the environment. That is what SB 181 demands. The legislative declaration of purpose is quite clear. You must, and I quote here, regulate the development and production of natural resources of oil and gas in the state of Colorado in a manner that protects public health, safety, and welfare, including protection of the environment and wildlife resources. That's a pretty simple declarative sentence. There shouldn't be questions about what that means. So in the case at hand, the issues are not so much whether the industry should have to report whether it's going to create a new disposal well out of a petered out one, but whether this action, both in the individual and the cumulative, is protective of the public and the environment on which we must all depend for life itself. So the fundamental issue at hand is whether the fracking industry's use of destructive and massive amounts of public water is a good idea. It is our opinion that it is not. And that is the issue you must address as highly paid public employees, even if you're still on training wheels, and one you've assiduously avoided in these rulemakings up to now. A related issue is, should the industry be allowed to dispose of the liquid, often radioactive, poison it generates in fracking into the public's groundwater? Might this water ever be needed on a planet that is warning from our use of fossil fuels? The double whammy is that all this is being allowed of an industry that loses money and loses it constantly. It is over $300 billion in debt in this country. Why do we continue this charade? These are fundamental issues you have to address. You simply have to. And they haven't been addressed yet. And so we'll continue to repeat these things as a mantra until somebody pays attention. I guess that sums up my comments. We'll continue to say these things. I would just, I've enjoyed Mr. Messner's comments over the past several weeks. I thought that, but he has an advantage over the rest of you. He's been there for quite a while. But he said the other day that he felt that your objective as a committee was to be neutral. Mr. Messner, that is not correct. Your job as public employees is to be advocates for the people, and that is to protect the public and our environment, which is being destroyed. And that is your only responsibility. And it should be the first thing you think about when you get up in the morning and go to your job. And it should be the only thing, in my opinion, you should think about. Thank you very much.
Thank you, Mr. Doe. Are there questions for Mr. Doe on behalf of Be the Change?
There never is.
Thank you, Mr. Doe.
Yep.
We move to La Plata County and San Miguel County. Mr. Iatridis. Good morning.
Good morning. I am looking to share a screen.
Very good.
Is it shared?
It is shared. Yes, thank you.
Great, thank you. La Plata and San Miguel really appreciate the consideration given by the commission to our concerns. And we know that you've asked for clarification on our issues in the statement of basis and purpose. And we hear very similar things as to what our goal is. And we hear staff's response to our requests, and we appreciate it. We know we're being heard. We are, however, a bit confused about some of the changes or the not changes. And I know there's so many issues going on, and perhaps some of these seem small compared to the other things that you're addressing. For us, they are significant, or we wouldn't be raising it, and I wouldn't even be raising it now in this 3-minute response. But I would just like to point out that while the statement of basis and purpose has made adjustments, it doesn't address a couple of issues that we think seem to be very straightforward, and we don't understand why wouldn't it be adopted. We haven't heard from staff, for example, that it's a bad idea or it would undermine something else. And one of the biggest issues is the burden of proof for these individual wells is still will cause a violation. Having done groundwater contamination cases for 30 years, I can tell you it's setting a burden that is rarely ever going to be met, as opposed to may cause. To try to demonstrate that a proposed UIC well is going to cause a violation is almost setting the bar so high that it'll rarely ever be met. With the precautionary principle, we think it should be may, which is the same as an 801A, and it just equalizes the two. So we haven't heard why that's not a good idea, so I just put it out to you again to adopt it. And then finally, in 801B, we ask that may adversely affect human health be adopted. We didn't hear any reason why it shouldn't be. It's the same as 801A. It makes a lot of sense. So we're just a little confused given the common goal that seems to be there. And then finally, with rules 806 and 07, we really appreciate the clarification that they do apply to existing facilities. But again, the condition was when there's a modification. And with many of these wells, that could be many years or even never. So our request is to apply them now, even if there's no modification. So with that, I will close. Thank you very much for your consideration of our request again and your patience with our requests.
Thank you for your closing and your presentation. Are there questions from commissioners? Great. Seeing none, we again appreciate your presentation. We will move to Karis. Good morning, Ms. Hill.
Good morning. Good morning to the commissioners, Director Murphy, and COGCC staff. Karis would like to echo the comments stated by Mr. Jim Martin, representing API, and Ms. Julia Ryan, representing KOGA. Karis supports the draft Rule 800 series proposed by COGCC staff, and we feel that this rulemaking reflects a very positive collaborative process. Karis would like to extend a huge thanks to the COGCC staff for the hard work and quick turnaround on the revised rules. So thank you.
Thank you very much. We appreciate that. I'm not seeing any questions, so we will thank you as well and move to Citizens for a Healthy Community.
Good morning, commissioners. Can
morning.
you see me? I would like to share my screen. Can you see that?
Not yet.
Okay, hold on a second.
And I would have the record reflect that Commissioner Putnam is now with us. Appreciate his presence. And we can now see your screen. Yes, we can.
Excellent, wonderful. Good morning, commissioners. Natasha Leger, Executive Director with Citizens for a Healthy Community. We generally support the 800 series as stated in our earlier comments, but we would like clarification on the reasoning for not extending seismic monitoring to production wells and have two suggested changes. And I'd like to turn it over to Chris to talk about those two suggested changes.
Good morning, commissioners and staff. It's a pleasure to speak with you all again. I'm wondering if you can still see Natasha's shared screen with me talking.
We can.
Okay. So during deliberations on Wednesday, we heard that induced seismicity from hydraulic fracturing is covered in the 300 and 400 series and the wellbore integrity rules. However, neither induced seismicity, seismic monitoring, nor traffic light protocol are specifically addressed in the 300 and 400 series or wellbore integrity rules. The COGCC's own permanent tech manager, Jane Stanzik, specifically stated that stimulation from hydraulic fracturing induces seismicity. And CHC can point to a host of scientific research to back up that statement. How is Ms. Stanzik's statement reconciled with the lack of seismic monitoring for production wells? It is also worth noting that most homeowners' insurance policies do not cover damage from hydraulic fracturing induced seismicity, which further indicates that it is a known adverse impact. We raised the issue of seismic monitoring in the 400 series, and staff said that it would be addressed in the 800 series. Once again, we thank staff for addressing seismic monitoring in the 800 series. However, we suggest extending the seismic monitoring language in 801F1 to the 400 series by either amending 408A or adding a section 438. CHC also wants to take this opportunity to once again press the COGCC to extend the general email notification list to both the 800 series and the 300 series. That is underground injection and oil and gas applications. Our main concern, as you know, is notice for water rights holders. Water rights are property rights, and damage to a water right constitutes damage to property. Oil and gas operations are known to have adverse impacts to both water quality and quantity. Therefore, water rights holders must have some way to receive notice of activities that may damage their property interest. CHC's proposed red line to incorporate the general email notification list in the 300 series and 800 series is not complicated. We propose that staff take the exact same language from Rule 504A3 and copy and paste it into the notice section of the 300 series and 800 series. Even if the COGCC takes the position that geographic notice is too complicated, which CHC disagrees with, providing general email notice for applications for underground injection and oil and gas operations is not. Once again, we'd like to thank staff and the commission for their hard work in this mission change rulemaking, and that concludes our testimony today.
Thank you. Do we have questions, commissioners? Commissioner McGowan.
Thank you, Mr. Chair. So thanks for talking again today. I'm wondering for the notification and the opt-in email list, are we contemplating an email list that doesn't require staff to figure out whether or not something is in proximity to the person who's opting in? It would be up to the person opting in to figure out if some sort of activity, whether it's drilling a well or converting a well, etc., that person would have to figure out if it's within their proximity and it's relevant to them. Because I think what I heard staff saying was it's going to be very difficult for us to figure out everybody who is a water right holder within a certain radius of an activity, for example. So if you're just saying there's this email list where people can opt in and be notified of any activity that the commission is conducting, I guess that would be different. So I think I need to understand better what you're asking for.
Correct. So staff has taken the position that the GIS mapping for proximity notice or geographic notice is too difficult to manage. We disagree with that, and we would like to see the email notification list extended to include geographic notice. But right now, what we're proposing, just as a first step, is for the general opt-in email notification list to extend to applications for oil and gas operations and applications for underground injection. So it would be up to the water right holder in our proposed language to determine whether or not, when they receive an email about an application or underground injection well, if that's within their geographic area or could potentially impact their quote unquote backyard. And Natasha, any clarification on that?
I was going to say the same thing. I just think at this stage, it's really important that an opt-in email notice is available to everyone that requests that, and understand that there should be some work done later on to try to fine-tune that from a geographic perspective. But really step one is making sure that the public can get notice without the burden being always on the public to check the COGCC website. I think that's really the important piece here.
Follow up, Commissioner McGowan.
Thank you.
Great. Other questions from commissioners for this panel? Great. Thank you for your closing and for bringing these points to us. We will now turn to the affiliated local government coalition, as well as City of Aurora and Gunnison County.
Good morning, commissioners. Elizabeth Pranos here on behalf of the Affiliated Local Government Coalition and the City of Aurora. I want to echo the statements made by others previously today, thanking staff for their tremendous work trying to finalize these rules, including working late, at least one evening this week, but I'm sure it was many evenings. So we really do genuinely appreciate all the hard work of staff. We do support the recent changes that address the conversion well issue. We think both the clarification in the statement of basis and purpose and the proposed rule language clarify the process by which an application to convert a production well to an injection well will be handled and the applicable requirements for that application, whether it's a 2A or a 2. With respect to whether local governments that own or operate active dams whose safety and integrity may be impacted by seismic activity stemming from an injection well, we still have concerns. We appreciate the language staff added to the statement of basis and purpose, documenting the historic practice staff has used to consult with the Division of Water Resources dam safety upon review of an application for an injection well. We understand staff will continue to use this consultation process going forward. And while it does provide us some comfort to know that personnel at dam safety will review proposed injection well applications and analyze whether, in their opinion, potential seismicity from the injection well may pose a safety risk to nearby dams, this process does not respond directly to nor satisfy fully our concerns. Local governments who own or operate dams within the 12-mile zone that may be adversely impacted by seismic activity need certainty that they will have knowledge of all applications for, in particular, Class 2 disposal wells that may pose a risk to the safety of their dams. This is so that the local government staff can respond to questions or concerns raised by local citizens about the proposed injection well, and where appropriate, based on their assessment of the potential risks to their dams, engage with the operator or the applicant and COGCC staff on the application to ensure that adequate protections are in place, whether that is monitoring or other protections, to minimize risks to dam safety. Relying on personnel at dam safety, Division of Water Resources, to contact local governments is just not sufficient. Those personnel have no obligation to contact local government owners or operators of dams. They also may determine, based on their individual review of an application for an injection well, that it is unnecessary to contact certain owners or operators. However, a local government that owns or operates dams may come to a different determination regarding the risk that a particular application pose. For these reasons, we continue to request that direct notice be provided by the applicant to local governments, in particular, that own or operate active dams within the 12-mile radius of the location of a planned Class 2 injection well. This would be language added to Rule 803D15. Thank you.
Ms. Paranos, a commissioner may have already asked this question, but is this information findable, readily available?
It is. So there is a link on the Division of Water Resources Dam Safety website, and it lists all, both active and abandoned, so the status of all dams by county. It also lists the contact name and the name of the dam, and it has the lat long, very specific location information as well.
Great, thank you. Appreciate that. Do other commissioners have questions? Ms. Paranos, one other question. We heard from Mr. Stir about additional changes to the rule and the statement of basis and purpose. And I know you probably saw that for the first time this morning, but do you have any comments about that?
Are you speaking to the rule with respect to converting a production well to an injection well? Yes. So we did, staff did reach out to us Wednesday evening. We did see that language. We are comfortable with that language, both the language in the rule as well as the language in the statement of basis and purpose.
Great, thank you. Other questions? Yeah, Commissioner Nanjaba, I was kind of thought you had the way you were moving. Go ahead.
Thank you. Thank you, Chair Robbins. And thank you, Ms. Pranos, for your comments. I just wanted to clarifying on what you just asked, Chairman Robbins. I wanted to be sure that was what you were answering, Ms. Pranos, was that the comments that were raised this morning from Mr. Sura about additional changes to the conversion well language, and adding that sort of following analysis with 304A, et cetera. Were you saying that you were comfortable with that language, or were you saying you were just comfortable with the way things are currently, or both?
So yes, so I have not had a chance to discuss Mr. Sura's language with my clients. I will say when staff went over the proposed language in the staff rule with me on Wednesday evening, that does look appropriate to myself and my clients. So we are comfortable with the staff language. I don't have an opinion one way or the other on Mr. Sura's additional changes.
Great, thank you, Commissioner Nanjapa, for that follow-up. Other questions for Ms. Paranos? Okay, great. Thank you very much. We continue to appreciate the Affiliated Local Government Coalition and Aurora's participation. We will now turn to Fritzler Resources.
Okay, am I online here?
Yes, we can hear you, Mr. Fritzler.
Okay, thank you. Chair, Commission, members of the staff, I greatly appreciate the effort you guys have put in. It's a massive effort, and it's going to be ending soon. So in any case, yeah, I have only one comment, and it's on 802A, and it's more or less, my concerns is the 3,000 milligram per liter limit on the aquifers seems to be a hard set limit. And it may just need some clarification or some more language if the aquifers contain hydrocarbons. That would provide for enhanced recovery projects to be more readily developed, but in any case, it just seems to be a hard set, and I think it would be reasonable to look at that language. I would like to cede any remaining time I have to the SOS group, and this ends my comments, but I do appreciate everything the staff's done and all the efforts you guys have put into this. Thank you.
Thank you for your closing statement. Questions? Commissioner McGowan?
Thank you, and thank you for following up today. I just want to clarify, I think what you're saying is there might be a situation where total dissolved solids are less than the 3,000 milligrams per liter, but there's hydrocarbons also in that water so that it would not be usable for drinking or agriculture. Is that what we're saying? And so therefore it should be clear that it might be eligible for injection?
Yes, yes.
Thank you.
Other questions? Okay, thank you, Mr. Fritzler, for your closing and for your participation. We now turn to Kendra Morgan.
Thank you, Chair. Bye.
Good morning, commissioners. Can you hear me?
We can.
Okay, let me do a quick screen share. Okay. So good morning, commissioners, staff, and Director Murphy. My name is Ana Gutierrez with Hogan Levels on behalf of Kinder Morgan CO2. To staff and Director Murphy, I just want to echo comments made by other parties this morning. We want to thank you again for your work on the 800 series. We think the discussions in this particular series, both in written testimony and verbally, really have allowed for open dialogue and have made good progress on this particular set of rules. And Kinder Morgan supports these rules with one final comment. On Wednesday, we testified on distinguishing between what is considered produced water and non-produced water. And in particular, we saw revisions from the staff on the statement of basis and purpose that that indicates their commitment to provide guidance on the difference between those two types of fluids that would be injected. And this is primarily for compliance concerns with reporting. I do think, and we really sincerely appreciate that. I think the concern, though, still does remain in the rule itself, because in the rule itself, you do still have an example of a non-produced water that is produced water. And so what we would recommend at this stage, because staff is going to have the opportunity to provide a little bit more dialogue in its guidance, a little bit more discussion around what are the different types of fluids, that we would just strike those examples of what are non-produced fluids under Rule 808A3 so that they have the opportunity to address any inconsistencies or any concerns with respect to non-produced and produced water in their guidance document. And then just for context, we think this is also appropriate because the Rule 807, which is the sister rule covering produced water, doesn't similarly provide guidance. So this approach would still be same in substance and form with the rest of the rule. And we don't think it substantively changes the rule, but would eliminate confusion. And that is our testimony this morning. I'm happy to take questions.
Thank you. Do we have questions? All right, seeing none, we thank you for your closing and your participation, and we would turn to Mr. Neslin on behalf of Occidental Petroleum Company and PDC Energy.
Good morning, commissioners. Can you hear me?
We can.
Very well. Dave Neslin speaking on behalf of Occidental and PDC. I'd like to add my thanks to the staff for all of their good work on this project and the rulemaking as a whole. We support the draft rules and the statement of basis and purpose as revised yesterday, and we urge you to adopt them. I want to just briefly respond to two issues that were raised this morning. The first was a request to extend seismic monitoring to hydraulic fracturing. And I just want to remind you that hydraulic fracturing is very, very, very different from wastewater disposal regarding both volumes of fluids and the duration of the injection process. Hydraulic fracturing, you're injecting fluids for a couple of days. Wastewater disposal, you're injecting fluids for years, potentially many years. The volumes are not comparable. We're differentiating between apples and oranges here. There is no technical evidence in the record that would support extending the seismic monitoring requirement to hydraulic fracturing. And Ms. Danzig is a member of the permitting group, not the engineering group. So there is no basis to extend seismic monitoring to hydraulic fracturing. There was also a request that you add a reference to the Form 2A analysis process to Rule 803B. That is not necessary. An operator is not going to be able to go off half charged and not understand they need to get a Form 2A if they do, because they separately have to get a Form 2 and a Form 31 and a Form 33. So they'll be in close contact with the staff if they are converting a production well to an injection well. And if a Form 2A is required or is potentially required, that will be looked at. So I would urge you not to make changes in response to either of those issues. Thank you.
Thank you, Mr. Neslin. Are there questions from commissioners? Commissioner Gonzalez.
Thank you, Mr. Chair, and thank you, Mr. Neslin, for kind of distinguishing between the hydraulic fracturing process as well as the injection process. I think there's a distinction that potentially could add some more clarity in regards to what happens to the water that is injected during the hydraulic fracturing process. So maybe you'd like to respond and inform us commissioners about that.
Certainly, Mr. Gonzalez. When water is injected for purposes of hydraulic fracturing, it flows back up the wellbore. That's the term flow back that we're going to be talking about as part of the 900 series rules. So the water is not injected into the formation on any kind of permanent or extended basis. Again, the injection process may last a couple of days at most, and then the water flows back. Most of the water flows back up to the surface and does not remain subsurface. So Commissioner Gonzalez, you're right, that is a third difference between the two practices.
Thank you for that answer. Other questions from commissioners? All right, seeing none, thank you, Mr. Neslin. Appreciate your continued work with us on behalf of your clients. We now will turn to Jason Moore with Small Operator Society.
Good morning. May I confirm that everyone can hear me since I'm on the phone today?
Yes, we can hear you, Mr. Moore.
Okay. Thank you, Chairman Robbins, and good morning, Commissioners and Director Murphy. I'm Jason Moore on behalf of the Small Operator Society. SOS would like to reiterate its appreciation for staff's work on the revised 800 series rule. We know it's been quite a lift, and you know, I think it's worked out well for this rule series. In particular, SOS supports staff's revisions regarding when a Form 2A may be required when converting an existing production well to a Class 2 UIC well. SOS agrees that such a conversion alone should not automatically trigger a Form 2A absent other facts indicating that the conversion rises to the level of being a significant change. Our most significant remaining concern is with revised Rule 802A, which would prohibit COGCC from classifying an aquifer as exempt if it contains less than 3,000 milligrams per liter of total dissolved solids. SOS members currently operate Class 2 UIC wells and aquifers that are not suitable for drinking water or agricultural purposes, even though TDS levels are below 3,000 milligrams per liter. We note that the revised statement of basis and purpose indicates that aquifer exemptions may not be granted where groundwater recovery is currently not economically or technologically practical to recover, but could potentially be economically recovered using future technologies. However, by prohibiting exemptions for aquifers that contain less than 3,000 milligrams per liter of TDS, the Commission will virtually ensure the immediate need to truck produced water to approved disposal facilities, thereby increasing truck traffic, noise, dust, and vehicle emissions. The only other option is to use pits, but the proposed 900 series rules would disallow unlined percolation and evaporation pits. And the cost to construct an effective lined evaporation pit can run into the hundreds of thousands of dollars, meaning many operators will simply choose to truck produced water for disposal. In addition, such pits would create a much larger surface area disturbance and impact in order to hold the large volumes of produced water. So we ask that this provision be removed or modified to preserve the ability to use aquifers with less than 3,000 milligrams per liter of TDS for Class 2 UIC wells if it contains hydrocarbons or is currently not economically or technologically practical to recover that groundwater for human or agricultural purposes. Lastly, I just want to say that we also agree with Mr. Neslin's remarks earlier today. And with that, I thank you and conclude my closing. Happy to answer any questions.
Thank you, Mr. Moore. Are there questions from commissioners? Okay, thank you very much, Mr. Moore. We do not have questions. We will unpanel you and bring on TEP Rocky Mountain. And I believe we will hear from Mr. Jewell.
Good morning, commissioners. Happy Friday. Thank you for your time this week. Real quickly, we thank Holly Hill of Karis for her perfectly stated sentiment to you guys. Thank you for listening and collaborating on this rule series, and we also support what has been done in the red lines. Thank you very much.
Great. Thank you. I went back up and looked at my notes, and Ms. Hill's statement was thanks. So we thank you for your thank you, and we
great collaboration as well. So
move to Weld Citizens, Weld Air and Water Wall of Women in Lowell and Margie Lewis.
And Mr. Chair, I'm not able to find a representative for the Weld Air Citizens in the meeting at the moment. So if indeed you are in the meeting and could raise your hand and let us know that you're here, we would appreciate it.
Ms. Larson, while we have a break in action, did 350 Colorado and the Lookout Alliance ever show up?
They have not.
Okay.
So we could proceed with Wellington Operating Group.
Let's do that.
All right.
Good morning, Mr. Chair and Commissioners. Wellington also thanks staff and the Commission for all the hard work that have gone into these rules. We believe that the staff's revised draft accurately reflects the deliberations of the Commission, while we still believe that it would be more reasonable and appropriate to limit the evaluation zone for induced seismicity. The draft reflects your deliberations, and we certainly respect that. So once again, thank you to everyone for the work that has gone into this.
Thank you very much. We appreciate that. Questions? Seeing none. Ms. Larson, I believe we can turn to the Western and Rural Local Government Coalition.
Yes.
Good morning, Mr. Nguyen.
Good morning. I don't have a lot to add today. I think y'all have done a great job on the 800.
on behalf of the Western Rural Local Government Coalition. We appreciate the hard work of this commission and staff to make improvements to the draft rules, some of which we requested, and also to the statement of basis and purpose. I think a lot of great work was done on the SBP in the last couple of days. We believe that the rules in the SBP strike the right balance, and especially appreciate current language in rules 803B and 304 that we had discussed. I would like to say, though, that issues surrounding potential induced seismicity issues, they are appropriately addressed fully as well, and we urge you to reject continued and unfounded calls that we're hearing from, like, Battlement Concern Group via Mr. Sura and Citizens for Healthy Community. The SBP is now clear and completely addresses how the commission can and should identify and account for induced seismicity in our view. CHC, I don't know, I don't know, we're scratching our head trying to understand what CHC is getting at. They're making these wild and absurd claims that well completions, a hydraulic fracturing process poses induced seismicity concerns. That's categorically false pretty much across Colorado, especially for that tiny slice of the North Fork Gunnison Valley where CHC resides and their concerns are. There's no such issue over there in Western Colorado, and especially for the very small handful of wells that are in the range of CHC concerns in their area. Also, Mr. Sura proposed additional language that's completely unnecessary. The current language in the rules address cumulative volumes, so there's really no need to add the language that he proposes. That just seems to be interjecting a false issue intended to force some unneeded seismic monitoring. We think your rules hit the right balance, so we'd ask you to just adopt the things around seismic as you currently have drafted. And with that, again, we look forward to working with you on the 1200 series, and we appreciate your great work and consideration of all the parties' testimony on 800.
Thank you, Mr. Nguyen. We too appreciate your group's efforts and perspective. And do we have questions?
I just realized I was barely on screen. Here I am.
Yeah, well, we saw the top of your head there. And, very good. Thank you again, and we will unimpanel you. Ms. Larson, do we still not have Weld Citizens or 350 at this point?
That is correct. Neither are in the meeting.
All right. I would suggest, and I'll just throw this out there, maybe let's take a 10-minute break and give them another 10 minutes to show up. And then if they're here, we can hear from them. And if not, we can close the closings and move to deliberations. Everybody okay with that? I'm seeing some nodding of the heads up and down, which is positive. So let's return at 10:05. It is 10:05, and we will get started again. Hearings Manager Larson, any finding of the 350 Colorado Lookout Alliance or the Weld Citizens groups?
No, Mr. Chair, neither are in the meeting at the moment.
Okay. Well, we will then close closing statements. And I, for one, would like to ask sort of an open-ended question of staff. We heard a lot of thanks for generating consensus on the red line that was the work product from the commissioner deliberation. So we thank you for that. We did hear a few additional suggested edits from some of the parties with objection from some of the other parties. So I would just wonder if staff could weigh in, and if you need more time, we can take a little more time of a break, or maybe you're ready to weigh in at this point. So thank you.
Thank you, Chair, for the question. And we took advantage of that time to try to organize our thoughts a little bit. And given the leadership of AAG Minor and Mr. Andrews on this, I am going to ask them to make some comments. So AAG Minor.
Thank you, Director Murphy and Mr. Chair. Staff would just like to provide a little bit of commentary in response to several of the points raised by the stakeholders in their closing comments. Starting with Battlement Concerned Citizens Group, Mr. Sura's clients, staff does not oppose changes that they suggested. We don't think that it would hurt to add those because both are consistent with staff's intent, but staff also don't think they're necessary. Staff does believe that the language as proposed is sufficient to achieve the outcomes, both in terms of the fact that the 304A process will dictate whether a Form 2A is required, in the language in the SBP about approaching sort of the cumulative impacts of multiple wells injecting into the same injection area. In terms of Citizens for Healthy Communities comments, staff does maintain that Ms. Stanzik, who is a trained geologist, one of many staffs who have a master's degree in geology, she was correct that there may be extremely low levels of induced seismicity that are caused by hydraulic fracturing, but because the magnitude of this seismicity is just so many orders of magnitude below that is associated with injection wells, and as I believe Mr. Neslin mentioned, it is temporary in nature, it's not long-term. To date, staff is not aware of any evidence that this very low magnitude seismicity has caused any risks of damage or even has been felt at the surface in Colorado. So staff does not believe that seismic monitoring for hydraulic fracturing is appropriate, at least given the geology of Colorado and the evidence and expertise that staff has in that to date. In terms of Citizens for Healthy Communities' other suggestion, staff is committed to continuing to work on our notice lists, but we're not sure that we need additional rules relating to that. The 500 series rules do already provide an opportunity to opt in to receive notice of any hearing application, which would cover any permit application, any oil and gas development permit application. So the only hearings that someone would not be notified of would be for the very small subset of conversion wells that are only required by a Form 2, and otherwise everything else there would be, that you could opt in and get the notice of that hearing application from the website. And of course, there is still the notice that is published on the Commission's website for that limited subset of injection wells. And it's worth really driving home here that staff has limited IT resources, and those are currently very focused on developing forms for the new rules. We are doing everything we can. The staff are working really hard to get those forms ready, knowing that we have an effective date coming up soon and a lot is changing. And as our IT resources free up, as the rules are implemented, then there may be more chances to evaluate how we can provide additional transparency with respect to sort of the opt-in notice system. Turning now to the comments from Fritzler and the Small Operator Society, the 3,000 milligrams per liter, I always want to say parts per million there, really reflects the interrelationship between CDPHE and EPA and the Commission, and we think it's appropriate to maintain it. It's worth noting that this is a current rule, Rule 324 capital B, little a subpart 3 provides that there's sort of a 3,000 minimum threshold of total dissolved solids for an aquifer exemption, and in the past, EPA has raised significant questions and concerns about any proposals for aquifer exemptions of groundwater with less than 3,000 total dissolved solid. It has allowed COGCC to approve some of those on a case-by-case basis in the past. And so staff thinks that it's appropriate to maintain the 3,000 limit in our new rule. And if there is a specific circumstance in which there could be an appropriate situation for an aquifer exemption for groundwater below 3,000 milligrams per liter total dissolved solid, it would be appropriate to address that through the variance process in Rule 502. In terms of Kinder Morgan's suggested language changes, staff does not support those, but is committed to continuing to work with Kinder Morgan as we recognize that this is an important issue for them. And just, again, the purpose of our rule on non-produced water providing some examples is that current Rule 316A, which also addresses the injection of non-produced water, only includes one example of what type of fluid that would be, and staff thinks that it was appropriate to expand that to include a few more examples so that parties aren't confused and thinking there's only one category of non-produced water that can be injected, but staff is committed to sort of fleshing out more about what that means in guidance. And then finally, addressing La Plata County and San Miguel County's comments, staff really does think that we are on the same page as La Plata County about the importance of protecting public health and drinking water in Rule 801, and staff is very open to perhaps meeting with La Plata County or their council or San Miguel County and their council to discuss their concerns further. And then I would like to turn it over to Mr. Andrews, who I think can provide a little more gloss on why the sampling requirements in rules 806 and 807 do indeed apply to existing wells.
Great, thank you. Mr. Andrews?
Thank you, AAG Minor. And commissioners, can you hear me okay?
We can.
Thank you. So I just wanted to go back to the slide that I presented this week on Rule 806 and specifically Rule 806B. So that's the periodic analysis. The intent of the periodic analysis is to ensure that operators are sampling when changes occur, and then also at a minimum every 5 years. So the statement that the sampling would never occur, I disagree with that. Perhaps instead of saying or in my slide, I could have said and. But the intent of the rule is to ensure that we are getting that periodic analysis.
Mr. Chair, if I may add one
Yes,
thing
please.
to that, it's important to note that these are existing rules that are being carried forward. The requirement for Form 26 is already found in current Rule 325C5, and Rule 324C also addresses sampling. So Mr. Andrews can perhaps expand on that, but existing wells have had sampling conducted already. So Mr. Andrews, do you want to expand on that at all?
Nothing further, no.
Great, thank you both for that. Mr. Minor, did you have anything further at this point?
I did not, Mr. Chair.
Great, that was a really great summation of the staff response, quickly pulled together and very accurately stated to the final suggestions that we had received from the parties in their second closing statements. With that, I would ask commissioners if there are further, or if there are questions for staff. Yeah, Commissioner Nanjapa.
I think actually Commissioner McGowan had her hand up first, so I'll defer to her.
Nope, you get to go first.
Okay, she's saying okay. All right, thank you, Mr. Chair. I just had a quick clarifying question in case I misunderstood, but so notice, with respect to the concerns raised about notice and water rights owners, et cetera. First of all, the opt-in email, I know we've discussed this before. So that allows for anyone to opt in to be noticed for any sort of application. And he said the only sort of exception that they would not receive a notice for would be the conversion wells. And I was just trying to think through from a water rights owner perspective, if there would be sort of significant different concerns with a conversion versus with a production well. In my mind, I would think that the concerns that would relate to their water rights, would be the same or maybe more in a production scenario. So I just wondered if you could maybe comment on that a little bit, or I don't know if there's anything more. Maybe this is more for our deliberation, but is there sort of a significant additional concern with respect to the water rights perspective from production versus conversion? I hope that
AAG Minor.
Yeah. Thank you, Mr. Chair. So I do want to perhaps correct my earlier statement somewhat. So the opt-in notice is for any hearing application, any hearing that will go to the commission. So that would be any oil and gas development plan. So any injection well that requires a Form 2A, which could be some conversion wells, but not necessarily all conversions. There would be opt-in notice for that because there would automatically be a hearing application on that. Additionally, if anyone protested a proposal for a conversion well that did not otherwise require a Form 2A, there would be a commission hearing, and therefore there could still be notice. So it's a very limited subset of those conversion wells for which there would not be an option for opt-in notice. in terms of the concerns of the water rights holders, I am not aware of why there would be perhaps additional concerns for sort of limited subset of conversion wells that don't result in additional surface disturbance or aren't a significant change to the well pad configuration. I think perhaps the greatest concern of a water rights holder would be the use of other water for perhaps hydraulic fracturing or other on-site purposes that would be more associated with the production well. But I'm not sure I fully grasp the scope of potential concerns a water rights holder would have. So if Director Murphy or Mr. Andrews has anything to add there, perhaps they can fill in.
Director Murphy, Mr. Andrews.
From my perspective, Commissioner, protections around water rights when we're talking about changes of use of a wellbore, the fact that the same wellbore construction rules apply to me is our greatest protection for groundwater. And so to me, and maybe this is kind of a corollary to Joel's comment that I don't totally, I understand that water rights holders are dedicated to making sure we have clean water. And I think that our rules through wellbore construction and through what has been proposed here, which is in coordination with both EPA and CDPHE's groundwater surface water considerations, achieves that goal. In terms of notice, we work very closely with DWR, the Division of Water Resources State Engineer's Office, with the dam safety team. And I think that organization is charged with dam safety across Colorado. And so I do think that they are the right people to be looking at it. And I think, and I just wanted to bring that out because I think it's one of the issues we forgot to touch on in our closing comments, but the dam safety program at the Division of Water Resources is a pretty incredible organization that is dedicated to dam safety specifically. So sorry for the little segue. And Mr. Andrews, of course, if you want to jump in on anything, please do.
Mr. Andrews.
Thank you. I have nothing further to add.
Very good. Commissioner Nanjapa.
Thank you. Thank you all for those comments. I just had one follow-up, which I'm not sure I may have missed in your closing remarks, is the suggestion from affiliated local governments with respect to notice to the local government for Class 2 UIC wells. And I thought we had that covered. I may have misunderstood, her comment as well, but I just wanted to make sure that we do have that covered. Is that correct? Within, I believe, is it 803? Yeah, I know that Joel probably has the specific subsection, but I did see this as I was just kind of looking through about surface owners and mineral owners with recorded ownerships and the relevant local governments, et cetera. So are we covered there from staff's perspective with respect to her comments?
AAG Minor.
Thank you, Mr. Chair. So you are correct, Commissioner Nanjapa. Rule 803G14, I believe, provides notice to local government of the essentially the injection well application. So that is something provided by an operator. That is given to the relevant local government. And of course, local governments get notice for any associated 300 series permits under the 300 series rules. I believe that's slightly different than the point that Ms. Braños was making, which is that if a local government owns a dam outside of sort of their own boundaries, they might not get notice under that provision. So from her statement, I would understand that perhaps the city of Aurora owns dams outside of the actual municipal boundaries of the city of Aurora.
Commissioner Nanjapa.
Thank you, AAG Minor. So do we, so then is that something that would have to be covered with the opt-in process, or, you know, what would, so if there were those scenarios of ownership outside of the municipality where that particular government, they would still receive notice, so they could potentially, well, I guess no, they would not receive notice if the location was outside of their municipality. So would that then, as of now, have to be covered through the opt-in process of notice?
AAG Minor, Director Murphy.
AG Minor, I don't know if you, we're,
Sure.
The awkwardness of Zoom sometimes happens.
Thank you, Mr. Chair. So there are multiple ways that a local government or other entity that owns a dam outside of its own borders could receive notice. Again, for anything for a hearing application, that they could just opt in to be on the email list and get notice of all permit applications. They could check the commission's website. And part of, I believe, our hope in continuing to provide notice to the Division of Water Resources is that, you know, the staff there would sort of contact any appropriate dam owners who could potentially be impacted. I am not specifically aware of how their practices work and if it is common for them to contact potentially impacted dam owners or not. But there are certain multiple pathways in which they could get notice of impacts to a project, you know, sort of within a radius of their infrastructure that is not within the municipal boundaries.
Okay, thank you. Appreciate that. That's helpful.
Other questions from commissioners? Commissioner McGowan.
Thank you, Mr. Chair. I just have two. One is, I just want to extra clarify for myself. Existing wells do have to sample and turn the results into our staff on some sort of regular basis, not only upon some sort of modification.
AAG Minor.
Thank you, Mr. Chair. That's correct, Commissioner McGowan. So I'll provide an overview and then Mr. Andrews can provide some gloss. So there is a sampling requirement in our existing rules. Ms. Byrne and Dr. Kaler are receiving those samples now for existing wells. Staff have proposed to expand that requirement to now require periodic sampling for all wells. So all injection wells are going to have to do sampling now every 5 years, both new and existing. And additionally, those samples will have to be taken at both new and existing wells when there's a change in the source fluids. So, Mr. Andrews, I don't know if you want to expand on that, sort of talk about what the Form 26 process is like now and sort of what data you and your staff are currently getting. That might be sort of helpful just for everyone to understand.
Mr. Andrews.
Sure. So the current Form 26, it's really geared around the initial application with a list of all source wells. And then, as I stated during my presentations, anytime a well is added or removed from that program, then a new Form 26 is required. And the Form 26 really includes data for both the injection well and then a representative set for new source wells. So if it's only one new well coming in, that may be just that single well sampled. But as I stated in my presentation, if a large group of wells come in, an operator acquires a new asset, we at least require a representative sample of those wells to determine whether or not that water chemistry is different than the existing source wells that may be going into that injection well.
Commissioner McGowan.
Thank you, Mr. Chair. So on a different note, and maybe I missed this, the comment about do we have a different bar in 801A and 801B with the may versus will? Sorry, if we talked, I missed that. If you covered that, Joel, I'm sorry.
AAG Minor.
Thank you. Sorry, unmuting problems. I did not specifically address that, Commissioner McGowan, other than saying that staff is very open to speaking with Mr. Yatridis or his clients about why we do view 801B as just as protective as, if not more protective as, than Rule 801A. To go a little more into it, the may that is in 801A, it discusses that may affect the health of persons or cause a violation of an EPA standard. In the will, there is a will in 801B, but it's important to note that there is also a will in 801A at the sort of beginning that the well will not be authorized. So, there is a component of protecting public health in 801B, and that is because it's cross-referencing WQCC Regulation 41, which sets very protective standards for domestic water use, and that includes considerations of public health in addition to other specific considerations of whether the water is currently being used for domestic sources, which is what's been added in the SPP. The staff's position is that there isn't necessarily a requirement for staff to prove, that there is going to be harm to human health from that groundwater contamination, because under 801B, because the language discusses that will cause a violation, essentially, of the WQCC standards, and so it's not about showing that someone would later go drink the water and have their health impacted, but rather is the potential proposed injection well, or more likely in this case, the component of the application package that relates to an aquifer exemption, inconsistent with the WQCC regulations for domestic use, which themselves protect public health. So it's somewhat perhaps convoluted, and perhaps the language could be clearer, but in staff's mind, because the domestic use and agricultural use criterion of WQCC are quite protective, and those are incorporated into 801B in many ways, 801B provides even greater protections for public health and for drinking water than 801A, because the EPA standards have sort of some more considerations built in that might not protect all of the same categories of water that the state classifications do.
I'm going to jump in on that question, Commissioner, and just say that this, I read the language as being fairly clear, but it goes down into a legal kind of the things that lawyers do best, right? Thinking about how words and fit on a page and together and interrelate with two other regulatory regimes. And I think the piece that I come back to consistently as I hear these conversations is that this is language that both EPA and Water Quality Control Division think carry out their missions and ours. And I fully support their analysis, of course. And I think that we've done a good job drafting it. And that's why we think it would make a lot of sense for us to sit down. The us in that sentence is probably Joel, but sitting down with La Plata and San Miguel and anybody else who has questions about how those work together legally, and working through it and helping them to try to, or giving us an opportunity to really walk through it at that really granular legal construction level. So.
I appreciate that. And I appreciate you also digging in a little bit more so everyone could hear what our staff thoughts were about how that language was put together so that folks can understand, including me. So I appreciate it. Thank you.
Thank you, Director Murphy. Thank you, AAG Minor. Other questions from commissioners to staff? All right, I'm not seeing other questions. So that concludes closing. Well, let me ask one last time. Ms. Larson, did either of our parties that didn't make it in at 9 ever show up?
Mr. Chair, I do not see either in the meeting.
Okay. Sorry, I do this every now and then. I have a fruit fly infestation at my house. With that, I believe we are now done with closing statements on the staff draft from 10-8. And I believe we now move into deliberations. AAG Davenport, do you want to provide us with any legal perspective on things that we may need to do at this point or not do? Can we just move into deliberations?
Yes, Mr. Chair, thank you. You can move into deliberations at this point. I don't think you need to do anything else, such as closing the record or something like that.
I guess that's kind of what I was wondering about. We're now in the 8, 9, and 12 series, and we don't need to close the record on 8 before we move into deliberation because we still have the 9 and 12 to keep going. Is that right?
That's right.
Okay. We're going to learn this rodeo as we do it. Okay. With that, I believe that we have before us deliberations on the staff draft that was delivered to us yesterday before the commission, and I would entertain deliberations. Thoughts, questions, concerns, ideas, notions, supposals. Commissioner Messner.
Thank you, Mr. Chair. And like many of the parties that we've heard from today, I do want to make sure that I'm expressing my sincere gratitude to staff and the stakeholders as they worked through in a tight time frame a lot of the topics that we had brought up during our initial deliberations. And so I'm very appreciative of that. I think that the draft, the most updated draft rules as presented, really do accomplish what I think our intent was. And so, so thank you for that. Couple of items that I'll bring up is I do think it is important, should there be the opportunity for Director Murphy and AAG Minor to converse with La Plata and San Miguel counties to ensure that there is clarity as far as the granular legal issues surrounding some of the topics that they had brought up. It does seem like we're on the same page there, but as a non-lawyer, I just want to make sure that the lawyers get together and make sure that legally everyone feels comfortable with the language. From the water rights perspective, I do think that there's kind of 3 concerns with water right holders. As a water right holder in the Western Slope myself, I think that there's downhole aquifer type of agriculture, water quality concerns. I do think that there's surface water, flood irrigation type of agricultural water rights concerns. And then I think that there's structural concerns around the integrity of water, irrigation water infrastructure. Having said that, I think that the rules actually do contemplate those things. I do think that the opportunity to opt in is there. I did have a conversation with a water right holder in the North Fork yesterday and talked to him about the opt-in process that's currently available. And that's what he was hoping would be available, and understanding that the opt-in would be, a breadth of information that would be provided for all hearings that would go in front of the COGCC. At least the one water right holder that I chatted to in the North Fork was comfortable being able to sift through that in order to determine, what was important to him. However, I think that as we continue to have capacity to be able to streamline our opt-in processes, I think it would be a good idea to just continue to look at ways to improve that over time. I do appreciate Mr. Sura's comments and some of his suggestions. I also appreciate staff's opinion that including them would not be a problem, wouldn't change the focus of the rules as drafted. I also think that they feel like the rules as drafted already accomplish what some of the suggestions are. I do think in 803B2, I would support including the after Rule 304 analysis suggested by Mr. Sura in that particular rule. I think in the statement of basis and purpose, however, based on conversations that we had yesterday, I'm comfortable with the existing language in that and how it contemplates potential cumulative impacts of multiple injection wells into one geologic formation. So I think that's the end of my comments at this point.
So Commissioner Messner, let me just make sure I've got this right. You would support the inclusion of the after a Rule 304A analysis parenthetical, but
That's
not
correct.
the inclusion of or into the same geologic formation by multiple UIC wells in the area. Is that right?
I mean, I'm ambivalent on that one because I do think that we've already accomplished that in the existing draft rules, but I think as AAG Minor indicated, the inclusion of that language, even in that section, wouldn't hurt or help, I guess, as far as how it would be applied in real life. So that one I'm ambivalent on, but I do support the 803B2.
Okay. Thank you for those initial comments, Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you, Commissioner Messner. A lot of your comments mirror mine. The one slight difference is I was going to suggest the opposite on the comments from Mr. Sura, but I could go either way as well, and I appreciate as well that the staff said, you know, no harm, but we believe that it's covered. So I'm okay either way on that one. I only had one other very minor thing that was more of a wording issue in the rules. It was not something that was raised by any of the stakeholders, and that was in 802B. It was something that I'd mentioned to staff previously, but the wording of 802B criteria for UIC aquifer exemptions, when I first read it, I asked, you know, may designate for what and exempted from what. It was a little bit unclear to me. So I would just suggest perhaps clarifying that to perhaps say may designate a UIC aquifer as exempt. You know, we're talking about that we are making exemptions, and so designate an exempted UIC aquifer seems a little bit confusing to me. So that's, again, a minor thing, but I would, I'll defer to staff on that, but I do think that could be a little bit clarified. But other than that, and beyond the comments that Commissioner Messner said, I don't have anything further.
Thank you. Unmuting myself. Commissioner Nanjapa for those points. I think it would be helpful for us, now that we're getting into the nitty-gritty on pieces of words, to have someone maybe screen share the draft that we're speaking about so that we can actually look at the words and make sure that we are all talking about the same thing. So thank you, whomever it is that started screen sharing, likely AAG Minor. If you could focus in on the language suggested by Commissioner Nanjapa. We can all take a quick look at that.
And Mr. Chair, if I may,
Yeah.
So the issue is that we are talking about criteria for exemptions, but then we say designate an exempted aquifer. To me, that's confusing language, and I think we should say designate as exempt or something to that effect.
Yep, I believe that this excellent change is being made on the fly.
If I may, Mr. Chair, Commissioner Nanjapa,
Yes,
did I correctly get your edit there?
Yes, I think that very well addresses that confusion for me. Thank you so much, AAG Minor.
Other thoughts, comments, deliberations from commissioners? Commissioner McGowan.
So I echo everything that my fellow commissioners have already stated. I think I'm just going to throw in there that I'm appreciative that staff is going to follow up on some things that have been brought up by some of the parties. So I'm appreciative that to address the 3,000 milligram per liter, there is a variance. You could apply for a variance if you're less than the 3,000 milligrams, but there's so many hydrocarbons that couldn't be used for drinking or agriculture. So I think that that issue has been resolved, or there's a way for that to be resolved. It sounds to me like follow up with La Plata just to work through that technical legalese. Sounds like we can do some follow up or some clarification for the examples of non-produced water, maybe in guidance or in discussions with the party. And it sounds to me, I just feel like a lot of work, really good work was done with the parties to come up with to resolution. And so I don't really have anything that I feel needs to be changed from my perspective.
Commissioner McGowan, while I've got you on the spot, did you have any thoughts about the 2 SURA additions? We've kind of got a split there with kind of a.
I was kind of leaning in the same direction as Commissioner Nanjapa, that it feels like it's been addressed, but but staff feels like it wouldn't hurt to add it, but I didn't feel like we needed to add it then. But if someone feels strongly about it, I'm fine adding it for clarification, adding further clarity.
Thank you for allowing me to put you on the spot.
Sorry, that wasn't helpful.
Commissioner Gonzalez.
Thank you, Chair Robbins, and thanks to all the other commissioners. I support the rules as written, including the minor changes that we've made here. I have no objections to the suggestions that have been made along the way. I think the rules are good. I think the clarity is good. Specific to your question about kind of the language that Mr. Sura presented, I don't believe that language is I don't think it cuts one way or another. And so when I read it, I think the rules are pretty clear that in fact there is the opportunity and the potential possibility for a two-way and a UIC application. I think the holistic approach of a UIC application is pretty thorough and captures, I think, the concerns that Mr. Sura was trying to bring up or trying to seek clarification on. So that's where I stand on that. And to reiterate, just the amazing work the staff has done. I want to echo that. This has been a tremendous process, and I think that the places that we've been able to land on the previous set of rules and on this set of rules, and I'm hoping for the next couple sets of rules, is just a really good example of coordination, of consensus building, and of really listening to all the stakeholders. So I applaud that. I encourage the staff to continue to work with stakeholders as they have questions about the rules that we are implementing, as they have questions about the language or any additional clarity they seek. And I hope that remains an ongoing conversation beyond just this rulemaking process, as I am sure that it will be. So with that, Mr. Chair, I support the rules as written, including the change reflected here on 802B.
Thank you very much, Mr. Gonzalez. Commissioner Messner, do you want to weigh back in on the suggested one edit versus another on Mr. Sura's suggestion? I think we're kind of a little bit ambivalent. And I guess I'm sort of inclined that having heard from staff that they're not opposed, but they also don't think it's necessary. I don't think things are going to get lost in the translation over the course of years. We've got a professional commission. We're going to be continually revisiting things. So I think we're in a good spot. Any further thoughts, comments, deliberation from anyone? Commissioner Messner.
Thank you, Mr. Chair. And like I indicated, I mean, I do think that the intent is there within the existing draft rules. I do think that the point that that I heard that I thought was a good one is that in particular the 803B2 after Rule 304 analysis language in the rule versus being only in the statement of basis and purpose was to ensure that that concept wasn't missed. But I do actually think that Mr. Neslin made a good point that there was a number of other forms that would be required to be submitted that would also require, close interaction with COGCC staff, and so would inherently enable that 304A analysis to occur. But having said that, to me, clarity is, if possible, always better. And if this is the intent for that analysis to be done, then let's put it in the rules.
Very good. Thank you. I'm looking at my fellow commissioners while also looking at the draft. I don't know. Do we want to just do a quick thumbs up, thumbs down on the after a Rule 304A analysis idea? And then maybe we can take a preliminary final vote on the rules as a whole. So why don't you throw a thumbs up if you would like to see the addition of after a Rule 304A analysis inserted into the draft. All right, so I think we're not going to insert that. I think that that's not like indicative of problem, etc. With that, I think the only edit that we then have is the edit from Commissioner Najapa, and AAG minor, the draft you have up, is this the 10-8 draft, just so that we've got a clean record?
Mr. Chair, this is actually a new 10-9 draft, just so that is exceptionally clear for everyone. But it does reflect the edits made on 10-8.
Okay. So I think at this point, unless there are questions, thoughts, additional comments from commissioners, I think we are at the spot to take a preliminary final vote or a straw poll on the 10-9 draft of the 800 series, as well as the statement of basis and purpose that goes along with it. As we did with the 2 through 6, this vote would be sort of a final vote on the substance of this 800 series. And we would then solidify a final vote on the 800 series once we are done with 8, 9, and 12, so in a couple of weeks. So with that, I would look for an AAG Davenport. Do I have this right procedurally in terms of what our next step should be?
Thank you, Mr. Chair. I think yes. One thing that I would want to clarify in any potential motion is whether or not there's still an opportunity for staff to potentially correct any proofreading edit issues in the 800 series or the associated SBP. That's the only thing that I would want to see, if there's still an opportunity for staff to do that in the interim.
So let's, if we're going to have this motion for a preliminary vote, have that subject to proofreading and typographical error review by staff or commissioners, if you're so inclined. Do I have a motion? Commissioner
Mr. Chair,
Najapa.
Sorry, I just had one other thought with respect specifically to the SBP, and it was, you know, I did have some outstanding questions about the seismic monitoring with hydraulic fracturing until this morning with some of the clarifying comments from stakeholders and from staff, and that was really helpful. And so I'm wondering if that would be useful to put a little bit of that explanation about that difference in the SBP as well. So that would just be one other suggestion, but I would defer to staff on how to handle that.
Okay, I'm turning to staff, someone, Director Murphy.
Commissioner Najapa, I think we can make that happen. You know, as part of the final SBP read through, we usually also pull in, you know, the comments of the commission itself, which when we put the draft version out, we don't have the benefit of course. And so there is kind of that last read through that's not just, and I did want a chance to ask the question also to make sure it was okay to add that kind of layer of detail to reflect the dialogue that happened as part of the hearing that framed the outcome. Because I think that in my experience as a lawyer, that's been very helpful if you didn't have the benefit of sitting through this week with us. So.
Very good. AAG Minor?
Thank you, Mr. Chair. I would also add, as I'm sure the commissioners and the parties are aware, the same introduction section of the SPP applies to the 900 series and the 1200 series. And so I think I would interpret what the commission's direction is that to essentially be currently applying just to the section of the SPP governing the 800 section, understanding that that introduction will continue to evolve as staff works on the 900 and 1200 series. So just wanted to clarify that that is correct, and I see some heads nodding.
Great, thank you for that clarification. Any further final thoughts? All right, seeing none, does anyone care to try to appropriately frame a motion? Commissioner Gonzalez.
Thank you, Mr. Chair. I'll take a swing at it. I hereby motion that we approve the substance of the rules in the SPP as written and in conformance with our deliberations today, subject to any additional language clarification or typographical errors in the rules or the SPP that do not substantially affect the substance of it. I'm winging it here, but I think that's my motion.
With your indulgence, Commissioner Gonzalez, I'd like to ask AAG Davenport to weigh in on the substance of your very fine motion.
Thank you, Mr. Chair. Thank you, Commissioner Gonzalez. I think it's a great motion. The only thing that I would clarify in it is that it's for the 800 series. And what your preliminary final approving here is the October 8 draft, subject to any changes made in the course of deliberations today.
Commissioner Gonzalez.
Mr. Chair, I'm happy to update that motion to motion for approval of the substance of the 800 series rules and the October 9th draft, I believe, is what Mr. Minor had put together for today, subject to any additional clarification in language and or typographical errors that staff may deem necessary that do not affect the substance of the rules as approved today.
Second.
We have a motion, we have a second. Are there further discussions on the motion? Seeing none, let's take a roll call vote on the motion. Hearings Manager Larson.
Can you hear me now, Mr. Chair?
We can.
Thank you. Commissioner Gonzalez.
Aye.
Commissioner McGowan.
Aye.
Mesner.
Aye.
Commissioner Nanjapa.
Aye.
Commissioner Robbins.
Aye.
Mr. Chair, it is a unanimous vote in approving the motion.
Great, thank you. Thank everyone for their participation in the 800 series. We will take this up at the conclusion of the 8, 9, and 12 for a final vote. But that vote does comprise our substantive vote on the 800 series. Really thank staff and thank all of our stakeholders for getting us to a very good place with regard to this series of our rules. And with that, I believe we now have concluded the business of the commission today, unless I'm missing anything, Hearings Manager Larson. And I believe we're looking for a motion to adjourn until, and I don't have my calendar in front of me, but is it Tuesday, October 13th at 1 p.m.? Is that right? And then at that point, we would take up public comment on the 1200 series of the wildlife rules that we're taking up. Is that right, Director Murphy?
Yes, sir.
So moved.
Do we have a second?
Second.
We have a motion and a second to adjourn until October 13th at 1 p.m. Any further discussion? All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Great work, folks. Thank you, everyone. Thank you to our 68 participants that are still with us. We will see you all on Tuesday, October 13th at 1 p.m., at which time we will initiate proceedings under the 1200 series. Bye.